Hello, hello. This is Leslie, your legacy lawyer, and it is Q&A Tuesday, where I answer an interesting question, or a question at least I think is interesting, that I've been recently asked in a consult, either with a new client or while I'm out and about networking in the community, or that was submitted by email or through our website. And this week, the question comes from Yadira, and she says, "Hi, I'm thinking of doing my estate planning, and I'm actually on the fence about potentially leaving a lot of money to my children who are 20 and 22 years of age. What kind of strings should I attach?" Hi, Yadira. Well, this is definitely a more common question and something you and your attorney, when you do decide to do estate planning, are going to spend a lot of time discussing. And honestly, what strings you should attach is going to be a very, very personal decision that you're going to make. But with that said, the good news is that your kids are not that young, in the sense that I always think it's more complicated when we do planning for very young children, because we don't know many things about their personality and about their behavior yet. By the time your kids are, and you said they're 20 and 22, or even when they're late teens, honestly, the chances are you already know a little bit about their personality, how they handle themselves, what they spend money on, what work ethic do they have, how responsible are they, etc. So also chances are is that you could kind of earmark a portion of that inheritance for their maintenance and medical issues or education, and specify ages for the other distributions if you don't think that at 20 and 22 they're all that responsible yet. And you're going to see it's very common to see those types of clauses in trusts, right? And that is what we're talking about right now, doing some type of trust planning, because in this case, when you want to restrict money, you would not leave that just in a will. And so of course the most common thing that we see is, a third, a third, a third, whether that's a third at 25, 30, 35, or 25% at 18, and then they get the rest at 25, 30, 35. Whatever it is, all of those things are going to be up to you and your spouse if you have one. But the even more important decision actually will be who you choose as trustee. Trustees generally have a whole lot of discretion, and the more aligned your values are with the person that you choose as trustee that will be left behind to make all of these decisions and make these distributions, the better. If you are not aligned, if you know that you would give your child the Honda Civic as their first car, and your trustee would allow them to go get a Beamer, then we have to actually draft into the trust more rules to make up for that difference in value. It's also really possible to layer a whole lot of other limitations and restrictions on the inheritance. One of the most common I see is forcing someone to go to college and complete college, or get a job, or have a career, quote unquote. And we would have to describe and define what those things mean, because again, we're trying to avoid the underwater basket weaving as a degree, just to get the inheritance faster, or a bonus, or whatever might be drafted into the documents. So these are called incentive clauses, and there is a very little limit to what you can do. There's so much flexibility there depending on what's valuable to you. And some of these things do seem a little ridiculous to other people, but remember, this is a very personal thing, and if you want to restrict that money, you can. It's your money. You restrict it as much as you want. There are people that think that it's perfectly okay for their child at 20 to inherit $1 million, or $5 million, or $10 million, or whatever it is. And there are other people that don't like that idea, even when their child is 35. So again, very personal decision to make. Another thing that I think is very common that I tell my clients, even at the age that you want distribution to happen, let's say ultimate distribution is at 30 to that child, you could actually still leave it to them in a protected vehicle in their own trust. And therefore, if they got a divorce after that, or if somebody sued them, there would be a lot of asset protection attached to that inheritance, and they wouldn't be able to lose it. So there are many, many options. And if you are a parent who has questions about how to leave your child an inheritance and what limitations make sense for your family, let's discuss. So until next week, remember, great families plan for great futures, and bye for now.